Just one. Okay, guys, I think we are ready to get started. I believe we have everybody here that's going to be here. We might have a few stragglers. I appreciate everybody making the time to come here. I will say this is my first ever briefing that I've ever attended, which is hilarious since I've been here 13 years. So I do understand the difficulty, in everybody's daily lives as far as, breaking out of what you're doing for those of you that have jobs, Brian. Making sure that we do whatever we do is important. So we're going to start out with a committee briefing with issues surrounding online data privacy from the NCSL. If you guys would like to come on up, I'd appreciate it. Thank you.
Yeah, we can switch.
And this is important, guys, because this is basically an overview. At 1:30, we're going to be coming back, and we're going to have additional individuals. They've been gracious enough to provide us an overview. But some of the subject matter we touched on last year and tried to push through, and I think some of it stalled in places it didn't need to. So we just want to give the committee an overview of what we're going to be dealing with this year as well.
Thank you so much, Chair Wilson and Vice Chair Crosby and members of the Maryland House Economic Matters Committee. We're so happy to be here this morning. My name is Susan Frederick, and I am Senior Federal Affairs Counsel for the National Conference of State Legislatures. I work in our Washington, D.C. office, and I am here today with my colleague Heather Morton, who works in our Denver office, and she is a director who handles all of our technology and internet issues for NCSL on the state side. So I do federal affairs, and Heather does all of our state research and chairs that department at NCSL. So I'm going to talk to you a little bit about our organization first before we get started. Oh, thank you. Oh, now everyone can hear me. Great. Just some little informational slides on what we do at NCSL. We are the preeminent organization that represents all 50 states and those of the U.S. territories, legislatures. And we have a state division and a federal affairs division as well. Our overview of today's meeting, we're going to talk about the federal legislation surrounding online data privacy, both the overarching comprehensive federal bill, and then we'll dive a little bit deeper and talk about children's online privacy bills that are pending currently in the Senate. With state legislation, we're going to talk more about comprehensive privacy bills in the states, and then children's online privacy bills that are moving as well. And then Heather will give you a little bit on health data privacy also. Just another lovely info. What we do at NCSL, obviously we do policy research. Heather handles a lot of that on the state side. I handle that on the federal affairs side. We are a premier networking opportunity for you as a state legislator. We have several meetings during the year and invitationals as well, where we bring together legislators from all over the country to talk about ideas, things that are germinating in your state, get tips and ideas from experts as well as your colleagues. We provide training for you all and for your legislative staff. I should note that legislative staff are also members of NCSL, along with the legislature, the legislators, and the legislature as a body, as the member organization. And then what I do, we are the voice of the states in Washington, D.C. So for lack of a better term, I'm a lobbyist. I'm an attorney as well, but I represent you all in the cumulative, all the states, on policy positions that you all vote on at NCSL's Legislative Summit meeting. And then we do have several meetings throughout the year, as I mentioned, where you can discuss and dive deeper into subject matter issues that are something that you would be looking at in your own legislature. So I'm going to now jump to the bills, which is why we're here today. And the first thing I want to talk about is the Federal Consumer Data Privacy Bill, which is called the American Data Privacy and Protection Act, the ADPPA. Now, this bill has been kind of tossed around in both houses of Congress for several years at this point. It has not passed. This is the closest that a bill has actually come to passing anywhere on consumer data privacy. But there are some things about it that you should know. The sticking points, at least from the state perspective and NCSL perspective, are twofold. So one is that states have kind of forged ahead with either comprehensive privacy bills or bills directed at a specific area of consumer data privacy. The federal bill would preempt all of those state laws. So whether it's comprehensive or piecemeal privacy legislation in the states, this federal bill would preempt it. There is a specific preemption provision contained within the bill. The other thing that is problematic for us as representatives of the states at NCSL is that it provides also a private right of action for consumers. Most of the bills that we see in the states provide for suits to be brought by a state attorney general. And so this would diverge from that and again would be preempted if this federal bill were to pass and become law. So the other political piece that I will mention is in the House, at least, the reason this bill has not moved is because California is one of the first states to pass a comprehensive consumer data protection law in its state. They have a state agency that's been set up to implement and regulate this issue in California, and the California delegation in the House is large. At the time that this bill was introduced and moved initially, Speaker Pelosi from California was the Speaker of the House, and it just could not move without giving special exceptions for what was being done in California under California state law. So that's kind of the situation with the overarching federal consumer data privacy bill. But I did want to point out one important piece. The ADPPA does an excellent job of defining what an algorithm is, and whether you're looking to pass privacy legislation here in Maryland or address artificial intelligence here in Maryland, which many states are starting to do. I wanted to give you this definition because it is very broad and very comprehensive. And by all experts that have looked at this issue, it seems to be the definition that meets legal muster. So wanted to make sure that you had that in our slides. Now let's talk about the main provisions of this bill, even though it has not yet passed, or maybe it won't. But to give you some idea of what it covers, it applies to most entities, including nonprofits. It has different requirements that apply to large data holders and service providers that use data on behalf of other entities. The covered data is defined as information that identifies or is linked or reasonably linked to an individual. So that is the federal definition of covered data. Limitations: it prohibits covered entities from using or transferring covered data to third parties unless it is reasonably necessary and proportionate to provide a service requested by the individual. And that's the important piece, whether it is reasonably necessary or proportionate. That seems to be the standard contained in this federal bill throughout its text. So that's a key phrase to keep in mind as you look to draft legislation here. It creates a special protection for sensitive data, which is deemed to be things like your social security number or your passport number or your driver's license number. You need to have the individual's consent in order to transfer that sensitive data to a third party. So that's another key provision. You have to have individual consent if we're talking about sensitive data. So health information, as I mentioned, social security numbers, anything that's really personal to you would need to have your consent to have it go to another entity. There is a transparency requirement as well. Covered entities must, it's mandatory that they disclose information about the data that they collect. So that's another key provision of this particular bill. And then consumer control and consent over the data collected You can access as an individual, you can access, correct, or delete it. Under this particular bill, they do address children defined as under 17. And then no targeted advertising to kids and knowledge of age is assumed. And then enforcement provisions, again, as I mentioned, there's a private right of action. And then also a state AG or the FTC, the Federal Trade Commission, has enforcement capabilities as well. So those are the main provisions of this particular federal bill. Why didn't this bill pass? As I explained in the Senate, the bill has not moved because it doesn't contain a strong enough provision for certain senators on a duty of loyalty requirement for covered entities. So they wanted stronger provisions to bind what the covered entity would have to owe to the individual. The California AG, as I mentioned, joined by 9 other attorneys generals, not Maryland, but 9 other attorneys generals, opposed the bill because of the preemption issue. So a very strong argument against preempting states. There's a very strong feeling among certain members of the Senate and the House at this point that there needs to be, if there's going to be federal legislation, it needs to be a floor, not a ceiling, so that states can actually enact their own privacy bills without fear of being summarily preempted in entirety as they move forward with their own legislation that's best for their state. So let's shift now to talk about children's online privacy. And there's a couple of bills I want to talk to you about. The original bill, which is the Children's Online Privacy Protection Act, or COPPA, and its accompanying rule, was passed a long time ago. It was passed in 1998. So it's a very, by today's standards, although I'm pretty old myself, but 1998, if you look back for a piece of legislation that has not been amended at all, that's a fairly old statute. The internet in 1998 is not what it is today. Social media didn't exist very much back then. So there's a lot of changes that have happened online for kids that is different now than it was when this bill passed. So the overall goal of COPPA is laudable. It is to limit what personally identifiable information can be collected from children without parental consent. Sounds very simple. I think that still remains the goal in most places today. Want to make sure that our kids are interacting safely online and that parents know what their kids are up to. So why is Congress interested in this seemingly overnight? Research has shown that the pandemic exacerbated mental health issues for youth and teens to a significant degree, that it caused a lot of stir and attention to that particular issue. The UK was actually the first to act legislatively on this issue, passing an age-appropriate design code known as the Children's Code, which has served as a blueprint for both Congress and the states. The law went into effect in September 2021. This is in the UK, and it set principles for platforms when designing products accessed by kids, including minimizing data collected, the implementation of parental controls, and turning off geolocation services. So President Biden, as a result of this, urged Congress to introduce and pass a kids' safety bill and privacy bill during the 2023 State of the Union address, which you may remember. So that is sort of the push that Congress needed to go forward to introduce these bills. So as a result of that, in July, the Senate Commerce Committee passed Children's Online Privacy Bill, the Children and Teens Online Privacy Protection Act, which is colloquially known as COPPA 2.0. Another bill that passed was the Kids Online Safety Act, or COSA, which is a similar bill, yet covers a little bit more extensively issues related to children and extends the protections to youth as well as teens under the age of 17 as well. And a lot of the things in the COSA bill are related to mental health, which I'll get into in just a minute. So before I get into the 2 new bills, let's just go over COPPA and the rule that accompanied it, just so that we get our bearings straight and we know from what we're working. This is COPPA and its regulatory accompaniment. It applies to kids under the age of 13. And the FTC issued this rule as a response to the statute, or in addition to the statute. It requires website operators to provide notice of the info that's being collected, obtain parental consent to the collection, and allow a parent to know what is being collected and give consent, yes or no, for that collection. Unfortunately, the reason why this has not proven terribly effective is because its enforcement provisions are very ambiguous. It's not really sure how to enforce this regulation, or to cite an entity for violating it. The FTC views a violation of this regulation as an unfair or deceptive practice, and there are safe harbor provisions in the bill or in the regulation if an industry group or other person meets a particular set of requirements. So enforcement has been lax. The Senate in particular viewed this as an opportunity to close some of the loopholes in the original COPPA bill and the regulation, which has not been terribly effective in regulating children's online privacy issues. So now let's talk about what they want to do. So both of these bills, the COPPA 2.0 and the COSA bill, are very, very much bipartisan, although COSA has 46 sponsors evenly distributed between Democrats and Republicans in the Senate. COPPA 2.0 has a few less co-sponsors, but again, fairly evenly distributed between Republicans and Democrats in the Senate. So it looks pretty good. The issue that I think is the most relevant here is the coverage, where COPPA only dealt with kids 13 and under. This bill, COPPA 2.0, raises that age, covers teens as well under the age of 17, as well as younger children. So it also defines very clearly what personal information means. And I'm just going to read you this very long list so that you get a sense. First and last name, home address, email, phone numbers, social security numbers, geolocation data, technology IDs such as retina imagery, fingerprints, voice prints, DNA. And it redefines verifiable consent to mean requests for authorization of future consent, and adds several rules of construction. Considering whether a website, online service, online application, or mobile application is directed to children, the commission, which is the FTC, will use a totality of the circumstances test, which is a decision that would be based on all available information rather than any one factor. So totality of the circumstances is a key phrase in COPPA 2.0, which means that all information, all verifiable facts will be considered when determining whether something is directed to children online. And the other things that will be considered would be intended audience of the website, and the mobile application of it as well. So it also adds language, knowledge fairly implied, which is on the basis of objective circumstances as a duty of care for operators. So again, those are the two key phrases here: totality of the circumstances, which we see throughout the text of this particular legislation, and then knowledge fairly implied, which kind of holds more responsibility and accountability for the website that is being looked at. The rule of construction for this particular duty of care is the commission will rely on competent empirical evidence, taking into account the totality of the circumstances, including consideration of whether the operator using available technology exercised reasonable care. So a lot of legal phrases in there: totality of circumstances, knowledge fairly implied, reasonable care. Those are all things that were put in there on purpose to hold operators more accountable for their actions directed at teens and kids. And here we're going to talk more about children's online privacy in the context of COSA, which is another bipartisan bill that I mentioned. Senator Blumenthal and Senator Blackburn have introduced this bill. It defines a covered platform to include messaging applications, video streaming services, online video games that are likely to be used by minors under 17, and is connected to the internet. So it expands the applicable services or entities or platforms that would apply to kids and teens. The focus again is on protecting the mental health of kids under 17 years old, and it will permit only age-appropriate advertising and uses the duty of care of actual knowledge or knowledge fairly implied based on objective circumstances again. Online platforms must prevent and mitigate harm to minors and not promote harmful behavior. And then some of the harmful behavior and the mitigation to minors in the context includes things like content directed at mental health disorders that cause mental health disorders such as anxiety, depression, and eating disorders. Content that promotes physical violence, online bullying or harassment, or sexual exploitation and abuse. Patterns of use that indicate or encourage addiction-like behaviors, promotion of narcotic drugs, and predatory, deceptive, or unfair marketing practices. So those are the harms that this bill is intended to prohibit or mitigate if they find it. The safeguards for minors is to limit the ability of others to communicate with a minor, prevent other users from seeing a minor's personal data, limit features of the online platforms such as automatic playing of media, and restrict sharing of geolocation data. So if the online platform knows that a user is a minor, they must default to the most protective settings within the context of whatever it is, the streaming service, the game, the chat. So they have a very strong duty to protect youth from being exposed to a lot of these things that we can find online. Parents have the ability to manage the settings of their minor children on their whatever they're using, their app, their streaming service, their computer. They can't advertise, an operator cannot advertise for illegal drugs. So if something is not legal in your state, it is the duty of the operator to make sure that that content cannot be viewed. There is a prohibition on dark patterns that trick or manipulate minors into clicking on something they wouldn't normally click on. So the clickbait stuff, they have to protect and mitigate from that as well. And then there are just certain disclosure requirements. If a minor chooses to purchase something online from one of these platforms, there are certain disclosures that have to be shown to that person before they can actually purchase anything. So if it's in-game, money or tokens, things like that. There are transparency and reporting requirements, which the covered platform has to issue a report describing reasonably foreseeable risks of harm, both physical and mental, to minors, and assessing the prevention and mitigation measures, which are the safeguards and parental tools to address them. Another important part. And then the rest of this bill lists a series of studies and findings that need to be made by certain entities. So the FTC, Federal Trade Commission, National Academy of Sciences, Health and Human Services Department of the federal government, NIST, which is the National Institute for Science and Technology. They are to all conduct age verification studies regarding technologically feasible ways to verify age. The FTC is to provide guidance with a new Kids Online Safety Council that would be established in this particular bill within 18 months of enactment, and guidance to schools is also required in collaboration with the Secretary of Education. So it's very comprehensive. Both of these bills have passed out of the Senate committees of jurisdiction. They are awaiting floor action in the Senate. The problem is obviously the House is not functioning at the moment. We do not have a speaker. They are not able to conduct any business. So even if it were to pass the Senate at this point, it is unknown what future it will face in the House of Representatives. So on the Senate side, Leader Schumer has stated both publicly and privately that this is a priority for him to get these two bipartisan bills at least through the Senate before the end of the year. So hopefully that will happen. In the House, again, if it were to miraculously elect a speaker today or soon. I know. House Energy and Commerce Committee Chair is Representative Kathy McMorris Rogers. She's a Republican from Washington State. She actually doesn't like either of these two bills. She would rather see the more the broader consumer data privacy bill, the ADPPA, pass. She sponsored that bill. She helped write it in the House, so she's got a favorite. But she might be able to be persuaded if some of the provisions from the other bill on the House side were put into this bill as it comes over from the Senate. So,
I did want to ask, because you're printing out a great deal of information. Did you want us to wait till you're done covering all of this? Because it's at your pleasure. As far as I know, I have a few questions, and I didn't want to wait till the end, or how would you like?
yeah,
us to
I'm
do it?
about to be done, so
Okay,
you can fire away.
I'll wait till you're done if you.
Okay. Okay. So, that's kind of the lay of the land for all of these federal bills. I would urge you to actually take a look at them if you're going to be drafting legislation here in your state. There are some really good provisions in the federal bill that I think are easily translatable to state legislation as well. And as you may or may not know, many state bills or many federal bills take their guidance from state legislation that has already passed. So with that little tip, I will be happy to answer any questions.
Well, thank you, ma'am. I know I have a few. I'm sure my colleagues may or may not have some, but I thank you again for your presentation. Just want to start out when you talked early on about sensitive data. You talked about social security numbers and health. Was biometrics a part of that definition?
No.
And do you know the rationale behind that?
I have to assume, I don't know for sure, but I have to assume that it was just not presented and put on the table. I think the goal was to be as comprehensive as possible. And that probably was something that did not come up.
And I asked that because I was wondering if you knew if the federal government had defined or has a federal definition of what biometrics would include.
I think they do in other legislation. I would look to the Department of Homeland Security for that information, because I think they are the ones that address the technology issues and have kind of the hold over what that should mean. I don't know that they have issued a particular rule that defines it.
Sure.
But I'm happy to get you that information.
And obviously we're here today because we are trying to we had drafted a privacy bill, a few of them actually. So obviously we'd be interested. Additionally, you spoke about duty of loyalty for covered entities. Should you expound upon that a little bit?
Yeah. So the issue with some of the two of the opponents of the federal legislation view the responsibilities and accountability factor of the covered entity to not be strong enough. And they would like to see stronger language that kind of keeps the covered entity more on the hook, gives them more responsibilities to the individual with respect to how their information is being treated. The way that some folks on the Senate in particular view this as it's too lax. There's still loopholes that allow a covered entity to not be transparent, to not talk about a duty of care to the consumer, to not disclose everything that it's going to do with your information. So they just want stronger language that really locks that in.
Thank you. Additionally, you talked about COPA, the first COPA, well, this one with the C. And there's COPA and COSA, I apologize. Yeah. There's COPA 2.0. So COPA, you said that you thought that the enforcement, or the ongoing message was that the enforcement was lackluster.
Yeah, it's essentially almost unenforceable as written, because there's not a lot of strings attached currently to how covered entities are to be regulated with respect to this particular issue, the disclosure of information and how it's to be dealt with. The FTC is, they're the main enforcement entity, and what they will do is they will say, okay, they'll get a complaint or they'll get, a charge levied, and they'll say this is a deceptive or unfair trade practice, but there's not a lot of meat attached to that particular punishment, if you will.
Okay.
So that's why that was viewed, at least on the Senate side, as needing to have more teeth in the enforcement mechanisms. There needs to be more corroboration and cooperation between the FTC and state attorneys general. There needs to be an opportunity to really hold a covered entities, a covered entity responsible for the things that it does. And so that's why they put all those terms in there, like you need, we're going to look at the totality of the circumstances, and we're going to look at what is fair, what is reasonable and fair in terms of, how we think this covered entity should conduct itself.
Sure. And now we're going to COPA 2.0.
Yeah.
One of the things that caught me was the verifiable consent.
Mm-hmm.
Now, what is that? How is that defined?
So verifiable consent would mean something other than, well, the parent said that it was okay.
So basically,
So a check the box or some sort of acknowledgement in writing that there's consent that's been given.
and consent, obviously, and this is where I was going, cannot be given by the juvenile, correct?
Correct.
And that's all right. I want to make sure that was a standard, otherwise it'd be
Yep.
pointless. And you talked about COSA.
Mhm.
The thing that I guess caught me was they're talking about the harmful behavior such as violence, mental anguish, addiction. So are they targeting, let's say, TikTok, or the individuals that the platforms that allow people to transform their bodies into something that's almost unrealistic? Is that what they're trying to keep from children?
I think you can make that argument.
And I just,
It's not named,
Correct.
there's no specific platform named in the bill. So it's not directed at TikTok,
of course,
but I think it would be incumbent on something like a TikTok to make sure that what, they would have to put into place, an age verification. So are you over the age of 17? Are you under the age of 17? If you're under the age of 17, there has to be some mechanism put in place that kids would not be able to see, somebody cooking meth or somebody,
sure.
like,
Well, and I think some of those, like learning how to make a bomb, is a little more obvious than people skewing a person's view of themselves. And because
Right.
this seemed to focus less on public danger than mental health of the child.
that's correct.
And so
This is
obviously,
purely a mental health bill.
correct.
And I think when you're talking about using artificial intelligence or generative AI to, alter voices, alter faces and bodies, that I think is a separate piece of legislation. Artificial intelligence was not contemplated in this.
And this
bill.
is more like apparently, and again, I don't have it, but my kids do, filters that are that get rid of your
Right.
blemishes.
Oh, right.
Some could consider that, or the way you can cinch in your waist,
Yeah.
or even
Yeah.
having letting kids see that as what could be considered an unreasonable body type. Does that seem to be the target there? Because I really didn't think of this on our last bill. Does that seem to be part of the target of this legislation?
I think you can argue yes. I think it's broad enough that it would encompass anything that could be shown to impact adversely a child or teen's mental health. And
Okay.
if that is body image, then yes.
And the last one's a little more complex. It's not complex, maybe just a hard question, because we are definitely talking about online platforms.
Yes.
Is that defined different than, say, a PlayStation video game? Because we're talking about violence or even addiction for that matter. But let's just go with the violence. That they're obviously, we've all grown up. Well, many of us have grown up on these video games, and they've obviously desensitized a large portion of our population. So are we talking about not just the ones you can play with your phone, but the ones that have anything to do with a Xbox, PS5, things of that
Yes,
nature?
because those are devices that are connected to the internet.
There we go. And that's only because they're connected to the internet, correct?
Correct.
And lastly, when you talk about addiction, I think that just seems very broad. So I'm interested in seeing if you give me a little more background, not now, but some other point, because the very act of having a phone almost seems addictive, and the very act of having TikTok on your phone, just that, and watching my children, 3 inches from their face flicking, Is that the addiction, or they talk about more of the gambling, or because video games can be addictive in themselves?
Yes.
So what do they mean? Do you, what do they target? What do they mean by addictive when it comes to our children? And if this is too vague of a question, I can refine it if need be.
No, I don't think it's a vague question. I think the term addiction as used in the bill is what's vague, because it doesn't specify whether it's the device, being addicted to the device itself, which is the phone,
Right.
or the iPad or the computer screen, in general, versus being addicted to something that they're doing. Like, are they binging TikTok? Are they spending 7 hours a day, looking at the Kardashians? I don't want,
No, I that's exactly where I was, because people binge Netflix.
right.
And I'm not saying this because it's fine when adults do it. It's not fine, but it's acceptable, I guess. But it is, I was just interested in what their views were when it comes to the, addictive behavior, because that's very broad.
They looked at the studies that came out really quickly post-pandemic on the impact of, having to be online so much during COVID, right? School was online in many, many places. Extracurricular activities, clubs, anything that your kids did, they had to do virtually. There wasn't a lot of personal interaction. So the online stuff took the place for a long time in certain places, of actually being involved, in person in something. So I think that, when those studies came out to show that being online so much had this direct impact on children and teens' mental health in general, I think that was kind of where they took up the ball, if you will, and said, okay, we need to do something about, having at least if we can't limit how much time kids spend online, which I think is really hard to do, even as a parent.
Right.
You don't know. I mean, your kid goes to someone else's house.
True.
They sit around on their phones for
Right.
2 hours. You can't control everything, right?
Yeah.
So, but what we can control is what these online platforms push out to our children. So I think that's where they kind of had to draw the line. Like,
Okay.
we can't control the device.
Sure.
We can control the information on the device.
And I'm always saying that because, again, we had both privacy bills and child protection bills. And I think some of the stuff we may have not included that I would like to include. So I wanted to make sure we are at least aligning ourselves with what the feds were doing. I know we have some questions from my colleagues. Delegate Fennell.
Hey, everyone. My question is, you talked about the legislation in 1998 that has not been revised in the state of Maryland. With the new proposed legislation on the federal level, which is the ADPPA legislation, that would, if passed in the federal government, that will preempt in reference to what we have here in the state of Maryland of 1998. So would that, if passed, would that be the basis of the legislation that will replace
Yes.
here? Okay.
It would replace whatever you've done in your state. It would
Okay.
preempt. Yep.
Okay. Thank you so much. I appreciate it.
You're
Thank you.
welcome.
We have the sharp dressed man, Delegate Boapo.
Thank you, Mr. Chairman. It's good to be back in committee. Susan, thanks for the presentation. I had one really quick question. I think my colleague Delegate Fennell kind of referenced to it. But in the beginning of the 118th Congress, Mr. Pallone, the minority, floated this idea of removing preemption, especially to try to get
Yes.
the California delegation on board. Where is that? Has there been talks with CMR on that? Obviously, that would be significant to states because it kind of goes into the patchwork.
Well, it killed the
situation.
bill back in 2018, the 118th Congress. I mean, we argued very strenuously against having that preemption provision. It killed the bill.
Right.
Has it been removed? No, it has not been removed. So if this were to continue to move, at least on the House side, I think we have friends more so on the Senate side for that issue than we do in the House. So the hard part will be getting the House to come away from preemption.
Right.
And I have to say that I think it's more of a political argument than it is a practical argument.
Yeah. And you were saying NCSL is in support of removing preemption from the federal
Correct.
bill. Thank you, Mr. Chairman.
Before I go to our next question, on the preemption, I guess my concern was just generally what it sounded like California, you said having a floor versus a ceiling, but doesn't that create a patchwork of legislation for businesses to try to follow through? Because
Yes,
we
it
have the same
does.
issue with our counties is everybody wants to be able to set their own standard, but it makes it very hard to do business in a state if every county has its own legislation. Doesn't that, because I know you guys are, well, you are state legislature, so I get it. But it seems like that's making it much more difficult to follow for any of these companies if every state has their own privacy statute.
You're not wrong. However, it is the feeling of most of the state legislatures as a body, as a cumulative body, when they come to NCSL, they want to be able to regulate the way they want to be able to regulate. And if there's a business already in a state doing business in that state, it's not necessarily viewed as a heavy lift for them to abide by that state's laws. Now, I think, you might have a smaller business that might have some trouble, or a new business coming in that wants to diversify and go to several states. But,
Do you believe that for online content? I mean, I
think
understand
that-
your regular business, but I TikTok, anything. Do you really believe that's and I know you have a job to do. I know what the title of your organization is, but it just sounds I'm a little bit taken aback that somehow they could modify to California and then Maine and then New York, no matter where, depending on that legislation, it seems very not only impractical, but damn near impossible.
Actually, and Heather will talk more about the state legislation. There are some common themes that exist in the states. And I
Without a
think-
doubt.
Yeah, and so I think that states that have done kind of these comprehensive bills. Oh, sorry. Okay. States that have done these comprehensive bills, they've looked at California, some of these later states, they've looked at the earlier states that were first out of the box to see kind of where there were obstacles.
I mean, they do, but they don't have
But
to.
I'll tell you, when we meet, so Heather and I staff are what is now our Artificial Intelligence, Cybersecurity and Privacy Task Force, or NCSL. And in that task force, we have legislators from all over the country, but we also have private sector folks that join us at every meeting. And I'm talking, the Googles, the Microsofts, the Intuits, the Oracles of the world. They all are there. And they are not upset that they have to comply, because they are used to it, I guess, at this point. And it doesn't seem to be as big of an obstacle that others who want the preemption would make it out to be. So I don't know that there's that big of a hurdle anymore. I think maybe when California's law came out and then, one or two other states, that might have been problematic. But now that these bills have been out for a couple of years, I think folks get used to it and they comply and they do what they need to do to be compliant.
Well, I'd be interesting again. I'm sure that California would define mental or harmful behavior different than maybe in New York or a Florida. Well, definitely Florida. But so again, but I appreciate your point. I think the next question we have is our senior statesman, Doug Ahrens.
Chair, I appreciate all you're saying here, and I understand you have it looks to me like you have a big wish list here of what you want to accomplish and what these bills should accomplish. And I guess the process as it is today isn't working.
Yeah.
It's
I
not
mean,
working. So when
reason,
when I sign into Apple, I am asked to go through terms and conditions, and
Yes.
everybody in this room clicks that yes, and they go.
and they
Those
don't
terms
read
and
it.
conditions where the meat is.
Yeah.
In any bill, or is it when they develop this, or when you're looking at developing, how is this going to be accomplished? Is there anything set in stone on how I will now watch so my children, when they do attempt to do something, is that process defined?
Not yet.
Okay, so this bill is really just get started. Everybody's now going to figure out how
Here-
to do it, but nobody knows how to do it
Yeah,
because we
here's
haven't
what
been
we
able to do
want.
it so
Here's
far.
what we want to have happen and to try to make this a better online environment for our kids. Like, here are the basic requirements that we need to have happen. Okay, FTC, start promulgating rules. okay, NIST and Health and Human Services, start conducting your research and your studies to figure out the best way to accomplish what this statute is requiring you to do.
Okay, so nobody really knows how to manage this just yet. This is all.
If they
a
do,
wish.
they haven't published it.
So we don't even have a fiscal note for this. So we want to
Yeah.
pass a bill that we're sending out, we're going to ask the people to sign on to, we're going to demand businesses do it. We have no clue what it will cost or how.
Well,
to
there
do it.
will be a fiscal note once it comes out of the Senate. So if a chamber passes a bill, there's going to be a fiscal note with that. And the committee, you know,
Let me ask you,
Yeah.
I don't mean to keep interrupting, though.
that's okay.
I will, I apologize. But when we do a bill here.
My husband does it all the time. I'm
What?
used to it.
When we do a bill, we put a bill out and we have a fiscal note. You're saying that
Yes.
that bill's been presented with no fiscal note.
Correct. They don't do it the same way that you guys do it in the state.
I guess I would be real interested in understanding how you do something and actually manage it, because the way we do things today, and I know you're going to change that, but I would like to really see a process on how that would work, because I think what you're doing is kind of, what it will do is kind of unmanageable at this point. For every time I hit a button, somebody's got to interact on that. And I think I just would like to know that process, if somebody knew it. That's all I want to say. Thank you.
I don't disagree with you. I think the implementation, the devil is in the details, right? So how this is going to be implemented, how this is going to be rolled out on a national scale, if it were to pass and be signed into law, those are the big questions.
I understand that. I mean, I think it would be a lot better for people to actually grab this and say, yes, you have a great idea, because I like the idea, but I don't know how it would be accomplished. And in order to vote for something on this level, I would like to know how that works, because I don't see it as manageable at this point. Thank you, Mr. Chair.
Oh, Stephen, with your BlackBerry, I'm sure you're not gonna have the problems the rest of us have with the internet connection, so. Right, so, but I'm sure with the flip phone or whatever you use, right. You just have to hit 9 a bunch of times. I get it. Our last question was Delegate Queen.
Thank you, Mr. Chairman. Thank you so much. And I'm glad I came here early to hear you.
You're very welcome.
So for the lawyers who are not part of this committee, I need more help with understanding of getting model legislation that we could use or pattern back behind. So that term of duty of loyalty, I didn't understand it, but I'm glad the chair asked about it for some more clarification. Can you point me to some legislation where I might find some words that would be in line with what you all are looking for when we talk about that topic? Because that's kind of, I don't understand that. So how would I?
On the duty of loyalty?
Duty of loyalty. What would the legislation say to make sure that we were accomplishing the goals there?
I think you'd have to use the term as a term of art.
Okay.
And then you'd have to define, duty of loyalty shall mean.
But does anyone else have it somewhere I can find that definition already so I can,
That's a good question. I'm going to let Heather.
Okay, so we'll get on Heather about that one.
Not federal legislation,
okay.
but maybe in a state bill somewhere.
Well, that's the other thing, because you did mention about some of the federal legislation patterns themselves after a federal, and Heather may be able to answer that. But could you point me to what states you would think we should model if we were going to look at these topics? You got California you mentioned, but is there some other ones that we might be able to get, the top, the most, the Mercedes or whatever of the legislation, and then the other ones is the day-to-day Prius like I drive. Can you get me some of that type of legislation, so where we can look and see the best that we can choose from? So I'll leave that to you, Heather. You're saying yes? Okay, thank you very much. All righty, thanks.
And I'm going to turn over this presentation to Heather. We're gonna switch chairs
Actually,
real
I think
quick.
You can just slide.
Oh, you want me to? Oh, you want
If
me
you
to?
just slide the keyboard over.
Okay, all right.
think
Maybe
it
we don't have
looks
to
like it
switch chair.
Yeah,
Okay,
but I don't,
there we go.
do you need to come bring the slides up? Okay.
We're tag teaming it today.
Yeah,
Yeah,
it's all
okay.
together.
Nope, didn't move. Try again. Mm-mm. There you go.
So I would just use the mouse.
Yeah.
Okay. And then just you're on the.
Backward. Turn this straight.
There we go. Okay. All right. Good morning and thank you, Mr. Chairman, Vice Chairman, and members of the committee for the opportunity to come and speak to you today. For the record, my name is Heather Morton and I cover privacy and technology issues for the National Conference of State Legislatures. And I'm pleased to provide you with an overview of the recent state legislative trends in privacy. As Susan mentioned earlier, I'll spend the bulk of my time highlighting 3 state privacy legislative trends, which are comprehensive data privacy legislation, children's online privacy, and health data privacy. Today's data protection efforts build from many iterations of privacy definitions that go back as far as 1928, when Supreme Court Justice Brandeis argued that the right to be let alone was the most comprehensive of rights and the one most valued by civilized men. The growth in internet, mobile, and social network connectivity has greatly increased the amount of personally identifiable data that consumers generate and share with companies and other third parties. And privacy issues are a growing concern for Americans, especially as the internet and technology have made this personal information more accessible, easier to collect, aggregate, and use. And as artificial intelligence continues to develop and grow, AI's need for data could put more pressure on policymakers to address privacy and security issues. And state legislatures have long been involved in regulating privacy of various types of information or by specific industry sectors. For example, laws that protect student information, individual social security numbers, medical information, and other types of information. However, consumer privacy issues have really grown in importance recently, especially in the 2023 legislative session year. And as you can see on this map in the gold color, at least 40 states and Puerto Rico introduced or considered at least 350 consumer privacy bills in 2023. And as of last week, there were at least 50 enacted bills and 2 adopted resolutions. Turning first to comprehensive data privacy, the California Consumer Privacy Act, or CCPA, gives state residents the right to know what personal information businesses collect, sell, or disclose about them, and to opt out of the sale of that information to third parties, among many other provisions. Enacted in 2018 as a compromise to stave off an even tougher proposed ballot initiative, the CCPA went into effect January 2020, and then a 2020 ballot initiative that was adopted or enacted, amending the CCPA, became fully operative this past January. Following California's lead, Colorado and Virginia enacted their respective privacy laws in 2021, and then they went into effect this past January. Connecticut and Utah followed in 2022. Then this year, 8 states, and that's Delaware, Florida, Indiana, Iowa, Montana, Oregon, Tennessee, and Texas, enacted comprehensive data privacy protection laws, bringing the grand total to 13 states. Many of these privacy laws contain substantially similar provisions, and some states have drawn inspiration from one or more states when crafting their legislation. However, each state's approach is a little unique, and when considering new consumer privacy laws in a jurisdiction, legislatures as you often tailor these provisions to the jurisdiction's unique needs. And the conversation around privacy frameworks often centers around the rights of the consumer. So like the right to copy, access, and correct, the right to delete or transfer personal data, the right to opt out of the sale or limit the use of personal data, and the right to non-discrimination are just a few. States are now also focusing on broader data management policies and principles like purpose and use limits, data collection minimization, and even retention disclosures. And in Virginia, as an example, controllers must limit the collection of data to only what is adequate, relevant, and reasonably necessary in relation to the purpose for which that data is processed. In some states like Colorado, they list specific processing purposes. And these purposes generally still require the consent of the consumer, but some allowances are made in certain states for purposes that are reasonably compatible with the disclosed purpose. Generally, covered businesses and other entities are defined either by revenue thresholds, data volume thresholds, or even just a requirement that the entity does business in the state. And the states with the comprehensive consumer privacy laws have generally agreed on similar definitions like controller and processor that are critical in determining requirements for data handlers. And these terms distinguish between these businesses that determine the purpose and means of processing personal data, which are the controllers, and the businesses that process personal data on behalf of the controller, which are the processors. And in Florida, Texas, and Virginia, certain government entities are exempt. And 11 of the 13 states require data protection or privacy assessments that document the processing, selling data, or other activities. And these assessments often focus on high-risk data processing activities, such as targeting, advertising, and profiling, the sale of personal data, or even processing of sensitive data. And with the increasing popularity of online platforms among children, some of the states have addressed children's data privacy concerns within their comprehensive data privacy laws. 9 states, and those are Colorado, Connecticut, Delaware, Indiana, Iowa, Montana, Oregon, Tennessee, and Virginia, they include personal data collected from a known child in their definitions of sensitive data. And then in addition, Colorado, Connecticut, Delaware, Florida, Indiana, Montana, Tennessee, and Virginia include sensitive data in the factors that trigger a data protection assessment. Colorado, Connecticut, Delaware, and Indiana require controllers to obtain consent from the parent or guardian before processing the sensitive data of a known child. Iowa, Montana, Tennessee, and Utah require that controllers process the personal data of known children in accordance with the federal Children's Online Privacy Protection Act, or COPA. There were 2, and I never remember which one's pronounced which way. I apologize. Florida prohibits controllers from selling personal data that is sensitive data without receiving prior consent from the consumer, or if that sensitive data is of a known child, without processing that data with the affirmative authorization by a known child who is between 13 and 18 years of age, or in accordance with COPA for a known child under the age of 13. Other states have introduced privacy legislation for children going beyond their comprehensive bills and even COPA itself. Last year, California enacted its age-appropriate design code, and the act requires a business that provides an online service, product, or feature that is likely to be accessed by children to configure all default privacy settings that are offered to a high level of privacy and provide privacy information, terms of service, policies, and community standards using clear language that's suited to the age of children likely to access that online service, product, or feature. In contrast, COPPA limits the collection of user data by website operators and services directed at children. COPPA protects children under the age of 13, while California's law applies to children under the age of 18. And the California law requires that businesses complete a data protection impact assessment to assess and mitigate risks from the data management practices for any online service, product, or feature that is offered to the public, and they have to create a timed plan to mitigate or eliminate the risk before children access that online service, product, or feature. And the businesses shall not collect, sell, share, or retain any precise geolocation data by default or personal information that's not necessary to provide that online service, product, or feature that a child is actively and knowingly engaged with, unless that business can demonstrate a compelling reason that the data collection is in the best interest of a child, of children likely to access the service, the product, the feature. And this slide that I'm showing lists the 8 items that businesses need to address as they perform their data protection impact assessment. And as you can see, it is very detailed. Not surprisingly, NetChoice, a national trade association of online businesses that share the goal of promoting free speech and free enterprise on the internet, has filed suit challenging the California Age-Appropriate Design Code Act as facially unconstitutional and preempted by federal law by COPA on December 14th, 2022. The U.S. District Court judge on the case granted NetChoice's motion for preliminary injunction in mid-September. And this month, California announced that it will be appealing that decision. And in 2023, 8 states, Connecticut, Illinois, and your state, Maryland, Nevada, New Jersey, New Mexico, and Oregon introduced similar age-appropriate design code bills. Other states have taken a different tact, instead focusing on parental consent or supervision. And many of these bills require parental consent to create social media accounts for children, and several of these bills give parents or guardians access to the content and interaction history in the child's account. Arkansas created its Social Media Safety Act requiring parental consent and age verification of the account holder. Louisiana created the Secure Online Child Interaction and Age Limitation Act that requires parental consent and gives parents the ability to initiate account supervision. And such supervision includes the ability for the parent to view the privacy settings of the minor's account, set daily time limits for the service, schedule breaks, and offer the minor the option to set up personal notifications so when the minor reports a person or issue, if there's problematic behavior or contact, I should say. Utah's Social Media Regulation Act gives parents or guardians access. They prohibit collecting, sharing, or using personal information from the account, and it prohibits the Utah minor account holder from having access to the account during the hours of 10:30 p.m. to 6:30 a.m. subject to parental or guardian direction. And as you might suspect, NetChoice has filed suit challenging the Arkansas law and was granted a preliminary injunction in August. And I would not be surprised at all if legal challenges to Louisiana's and Utah's laws are filed in the future. The age verification provisions that are in these bills raise their own privacy concerns, as the process may require businesses to collect and retain additional information to verify the age of account holders. And with more than 40 bills that have been filed in 2023, I fully expect to see more bills focused on children's online privacy in 2024. Turning now to health data privacy, recognizing that many mobile phone applications and websites that are collecting health-related data, and that these services may not fall under the definitions of who must comply with the Federal Health Insurance Portability and Accountability Act, or HIPAA, state legislators have turned to including health data under their comprehensive data protection statutes or creating health-specific provisions as standalone legislation. With the Supreme Court's Dobbs decision overturning Roe v. Wade, possibly having ramifications for other privacy-related case decisions that followed Roe, efforts to protect health and other sensitive data have increased. In their comprehensive data privacy bills, there are 10 states, and those are Colorado, Connecticut, Florida, Indiana, Iowa, Montana, Oregon, Tennessee, Texas, and Virginia. They include mental or physical health condition or diagnosis within the definition of sensitive data. Utah includes information that regards an individual's medical history, mental or physical health condition, or medical treatment or diagnosis by a healthcare professional. And similar to Utah's law, Delaware statute includes a mental or physical health condition or diagnosis, and they specifically include pregnancy. And as an example, the period tracking apps that are out there and that many people use are often not covered under HIPAA unless that company bills for healthcare services. Companies who provide free apps but monetize that data are not required to protect personal data under HIPAA. And as an example of a standalone legislation enacted this year, Washington created My Health, My Data law. And in that law, they defined consumer health data to include personal information that's linked or reasonably linkable to a consumer and identifies the consumer's past, present, or future physical or mental health status. Beyond the comprehensive data privacy legislation, there were 16 other bills were introduced in 2022, and 43 bills are in progress through the 2023 session that specifically focus on health data privacy. And now that I have summarized the recent state legislative trends in privacy policymaking on this slide, here are links to the state legislative tracking that I maintain on consumer data privacy on NCSL's website. And I included the link to the legislator guide on privacy and glossary of privacy terms that was produced by the NCSL's task force on artificial intelligence cybersecurity and privacy that Susan and I staff. And as I'm winding up my presentation, here's a quick shameless plug for the upcoming base camp, since I have you captive, our virtual meeting and oops. Oh, that works. That too. Forecast 24, where you can learn and interact with your colleagues across the states in case you're interested in attending and haven't already registered. And I would be remiss if I didn't share suggestions for ways that you can access NCSL and all of our resources. And finally, thank you, Madam Chair, for the opportunity to provide testimony on recent state legislative activities regarding data privacy. And that includes the comprehensive data privacy, the children's online privacy, and the health data privacy. And I'm happy to answer any questions and provide additional information if needed. And my contact information is available on this final slide. Thank you so much.
Thank you, Ms. Frederick. Are there any questions? Delegate Sample Hughes.
Madam Chair, thank you for the presentation. Very thorough. I'm trying to keep up with you taking
I know.
notes, but I do know where to find you. I did want to just ask you, just for clarity, because I think I picked up on it and I'm not for certain, but you had mentioned about the online apps, something that they don't have to do if they don't charge, I guess, like insurance. And the one that I was trying to get a little bit clarity on, is that an example like the Fitbit? You know how Fitbit will ask you about your mental health and your menstrual cycle. I mean, all of these laid out, personal information. And so I was just curious, are you talking about that type of app and what are they not able to do? That's the piece that I missed.
Thank you, Madam Chair. Thank you, Delegate. Yes, absolutely. So that's the health data. And that's an example exactly like that Fitbit is collecting information that could be included, as well as there are, I think if you go, like some websites, right, where you're searching for health data or something like that, they can put like code on the website that are essentially like little cookies or little trackers and all of that, whether or not, and so they're figuring out because they can get your URL address, they can sort of get all sort of information about you and then what you're searching and kind of aggregate that and create information about you. So some of that's what I think that they are, some of the states, by doing these health privacy bills, that's what they're getting after. And then, and like I said, with, because you do have the apps, right, that are period tracking that, so, when you have it, when you don't have it, all that kind of stuff. And those are at the moment, for the most part, they're not covered under that federal HIPAA law, even though that is health information. But if the app is somehow, if it is billing, it becomes a provider, so if it's, I guess it'd be like, and I don't know for sure, but it would be something like maybe like your insurance company creates one or your doctor's office creates one. And I'm not sure if they do, but something where like that, where they fall under the definition of a provider under HIPAA, then they would be covered by it. But if they're not, and it's just a free app on your phone and it's, I don't know, XYZ Media, whatever, whoever creates it. And if they don't meet that definition of a provider, then they don't have to comply with HIPAA and they can do what they, at this point, right? Unless there's anything, they could pretty much do what they want with the data.
Okay. Thank you so much for the clarity.
Thank you.
Delegate Fennell.
Madam Chair, my question is, and I heard you talk about the other states that deal with the sensitivity of the mental health. Now, is the state of, with the HIPAA law, is that preventing the state of Maryland to deal with the sensitivity of the mental health issue dealing with, because I know we do the 17 and under in reference to data breach. Is that prohibiting or interfering in reference to with the information of the mental health?
Thank you, Madam Chair. Delegate. To be honest, I'm afraid I don't know for sure if HIPAA preempts that. So I would need to do some research and get back to you. Okay. Yeah. So just to make sure that I understand. So does HIPAA preempt mental health data? Okay, thank you.
Delegate Frazier Hidalgo.
We good? Okay, good. Thank you, Madam Chair. So with all of the different laws and all of the different potential policies moving forward across all the states and the feds as well, my question surround is how are the companies, the Instagrams and the Facebooks, how are they reacting to this? What I'm gonna probably suggest from their perspective is an onslaught of legislation that is, past its time coming. So how are they reacting? How are they acting? What are they doing in other states? Are they accepting any of this? Are they fighting? If they are fighting, how are they fighting?
Madam Chair, Delegate, thank you. I don't exactly know for sure exactly how they're fighting it, but I would say that, yes, I'm sure that these national companies, Instagrams, Meta, TikTok, all of them, even Google and, all of them, absolutely, they have lobbyists and they definitely have a position that they want to advocate for. I'm sure that there are provisions that they feel would be onerous for them. And so they would absolutely come and share that information with you and try to convince you otherwise. So absolutely, they are doing that. I think at this point, and similar to Delegate Wilson's questions earlier, I think most of them, I think, would agree that yes, they would prefer to have a national single standard that they want to follow. And that's why, of course, they're lobbying at the federal level, of course, for federal legislation that would, that would preempt the states. But I think, from most of the position, and some of the states, I think maybe, have the position that, that they, that they may not necessarily have a problem with having a single standard. I guess it's more they get into the question of whether or not it's a floor or a ceiling. So that if the state has enacted legislation like California's, where maybe it goes beyond federal law, that they want to be able to keep that right, to keep those laws in place.
The states do.
Right. And yeah, exactly. So, but yeah, absolutely. The companies absolutely are going out there and they're lobbying and trying to get their voice heard. And when the states are enacting these bills. And that's why I think you've seen as well with some of the provisions that California was the first one to enact the Comprehensive Data Privacy Bill. And some of the provisions that California passed have not followed in the states that have enacted since, right? They have, some of them have said, you know what, maybe we don't agree with that. Maybe that goes too far. We're going to do it our way instead. And so the states, as they're going through these bills, right, they're looking at, okay, what did California do? What did Connecticut do? What did Virginia do? And pulling ideas from those and saying, you know what, we like that idea better. We're going to go with maybe what Virginia said or with what Connecticut said or what Texas did instead of what California did. So
I guess that's great. Thank you. And I guess my follow-up to you would be more of an ask. And I don't know if this is how big of an ask this is for you all. Is there an ability to put together kind of a frequently debated argument that's used by them? Because I'm going to assume that they have probably the same 5 or 4 or 3 or 7 arguments that they are pushing through all the states in the country. And it would just be interesting to get a little bit ahead of that, because it's just kind of a big information game. I mean, we had a couple of bills. I had a bill that was in judiciary, and there's a couple of bills that go all over the place, but it would be interesting to kind of see what they're arguing, just so that we have a little bit of a preview, and can better prepare for those arguments. Thank you.
thank you, Mr. Chair, Delegate. I don't know necessarily that we have specifically their arguments, but but definitely that yeah.
We know what they say.
Yeah.
Okay, well, if there's like a Q&A or just a bunch of, allegations, that it would be great to just get ahead of it.
Yeah. And I think also that the legislator's guide and a privacy guide and glossary of terms, that will give you, especially you can look at the glossary of terms, because what we've done is we went through and actually listed all of the definitions and who has what
Okay.
and noted that so that then you can kind of see where you can see the similarities and the differences to help you as you're drafting the comprehensive data privacy.
Thank you so much.
Thank you.
Delegate Adams.
Vice Chair. So good morning to you, and I'll just be brief and maybe segue off of Delegate Frazier Hidalgo's points, which is that, you know, most businesses want to stay in compliance, and if they're out of compliance, come into compliance with law. I would say any of these companies, whether it's Facebook or you know, smaller private businesses that collect and use data, want that same laudable goal, right? So the question that I have for you is that with that understanding, and I think we have to work with that understanding, isn't it easier for compliance to happen when you are passing a federal law as opposed to having each state decide for itself what compliance looks like? And frankly, we are a nation of individual states and we have some self-determination, so I get that. But on an issue like this, when you're asking a national company with a footprint to stay in quote unquote compliance, this laudable goal, I'm just simply saying, isn't it easier to achieve that at a national level and really strive for national solutions as opposed to this idea that we're going to have this general consensus over time because enough states have acted in a consistent way, and now the federal government's going to take that model legislation and all of a sudden turn it into federal law. I just asked the question out of just good faith to what I know businesses aren't inherently trying to take advantage of citizens. I think they're trying to operate in a free market system with rules that are consistent and applicable across the country.
Thank you, Mr. Chair. Delegate, I think probably in practice, what happens currently, since we have the 13 states, although a few of them, of course, have not become effective yet. They were just passed this year. But I imagine that at a practical level right now, the companies, what they're doing is that they are working, you know, like in compliance to whatever state has the hardest or the highest standards. And then all the others underneath that probably fall under that, would fall under those provisions, right? That they would be safe in that sense. But then, and so absolutely like I said, the companies absolutely are trying to get a single standard. But in practice, you know, like right now, they're probably working towards that by using whatever what they perceive as the highest standard that the states have enacted so far. I don't know.
Yeah, I can add a little bit to that. So when we've been talking to Congress about what to do with respect to comprehensive privacy legislation at the federal level, we have always argued for a couple of things. We'd like a seat at the table so that you can learn about what states have already done to help inform your direction when you draft a federal bill. The second thing is, you know, the floor, not the ceiling. So if states want to go stricter, stronger than what a federal piece of legislation provides, that they can do that if they have the infrastructure and the mechanisms in place to do that in their state. So those are like our two biggest arguments. And then on the preemption provision, because it's a blanket preemption as currently drafted, that it doesn't take into account some of the good features that are in state legislation. It doesn't take into account, you know, what implementation would look like. So that's why that kind of circles back around to our argument. Create some guidelines, create guidance for these companies that, you know, they can follow these baseline provisions and come into compliance. But then if a state, for example, California, which was the first one out of the box, you know, they have different requirements than most every other state in the country right now. So, you know, get the threshold requirements in place and then let states go further, stricter, stronger, if that's what their constituents and their citizens want to see from privacy legislation. But to date, we have not even had a seat at the table. So that to me is very problematic that, you know, Congress is not really paying any attention at all to what states have already done. They're just kind of forging ahead with their own ideas without bringing in folks that have already been through this and enacted things, you know, at the state level.
I don't think anyone's shocked.
I am personally shocked.
Oh, no, Okay, seeing no further questions, thank you both so much for your brief. We really appreciate your time, and this is such an important issue, and I know that's why the chair scheduled it first. So with that, I think that concludes the first portion of the briefing. Next, we'll move to unemployment insurance.
Well, thank you very much for having us.
Yep.
We love coming up here. Beautiful, beautiful, beautiful hearing room.
All right, we have Jason Perkins Cohen, EJ Shoebridge, Rachel Brash, and the man, the myth, the legend, Andrew Fulgeniti. And Mr. Perkins Cohen, you're first up. So whenever you're ready, if you could just have a microphone.
Yeah.
All four of you can come up all at once. We'll just save the transition time. Don't be shy, Andrew.
I'll go ahead and get started. Yeah. Good afternoon, Mr. Vice Chairman, members of the committee. My name is Jason Perkins Cohen. I'm the Deputy Secretary here at Maryland Labor. I'm very happy to be with you today. I do have to bring the regrets of Secretary Wu, who is sorry she can't make it in person, but she looks forward to working with you all things Maryland Labor before, during, and after session. Just a quick note about me. I came to Maryland Labor in March of this year. Previous to my appointment here, I was the employment director for the city of Baltimore. And before that, I ran a nonprofit organization, a workforce development organization that provided occupational skills training to Marylanders. And we also had an advocacy arm as well. So I had the opportunity to appear before this committee numerous times and was even on, at one point, the Unemployment Insurance Task Force. So it's good to be back and good to be working on these issues. And I look forward to working with all of you. As you mentioned, I'm joined today by some of my colleagues. We have EJ Shoebridge from our unemployment insurance system. We have Rachel Brash, who has been working hard on the loan program. And we have Andrew Fulgeniti and Catherine Bach, who are part of our LEDGE team. So we've given you some slides. Before we dive into that, I do want to just talk big picture for just a moment. I feel certain that I speak for all of us. All of us are hoping that we don't have a shutdown and that Congress is able to find a way to come to agreement. However, if they are unable to do so, we need to be ready. We know that Marylanders, particularly Marylanders who work for the federal government, will be impacted. And that impact, that harm will increase with each day, with each week. I don't even want to say it, but if it happens to go beyond a month, that impact will be greater. So at Maryland Labor, we need to be ready, and we are trying to balance two goals. One is to make sure that Marylanders who are eligible for one of the two programs that we have available, that we're using the tools that are given to us by statute to make sure that they can get access to resources as they need it and as they are supposed to through the eligibility criteria. At the same time, we also have to make sure, as good stewards of public resources, that individuals or organizations who are trying to do harm, who are trying to commit fraud, don't have access to those resources. And it's a balancing act, and we want to stay in balance. To take the extreme, if we made it very easy, very fast, which is a goal, we would be potentially opening up ourselves to more fraud. If we went on the other extreme, if you want to totally eliminate fraud, the way to do that, which we don't want to do, is to have so many barriers that no one can actually receive the services. So finding that right balance is a continuous challenge for us. And we will continue navigating that as we do with unemployment insurance and as we'll do with this loan. So if we want to, do you mind just, thanks. Just jumping into the slides, first, just to level set us on the potential impact of a shutdown. And again, this may be fairly obvious, but it's good to start here. So each federal agency without an approved budget will have to designate its workers. It'll happen agency by agency, and there's one of three designations that they can use. The first is exempt workers. These are workers who are required to continue to work, but are still being paid. So they're working and still getting paid, which means they're not directly impacted by the shutdown. We're not really talking about them today, but we do want to mention them because you may hear the term. Also, it helps to explain the numbers. The other two groups we will be talking about. These are, again, designations that the federal agency will determine for its workforce. There are accepted workers, which are also called essential workers. Like exempt workers, they are required to continue working during the shutdown. But unlike exempt workers, they're not paid. So because they're required to work, they're not eligible for unemployment insurance. Because they're not paid, they're obviously impacted financially by the shutdown, and that's where the loan program came from. We'll talk about that in a second. And the third category of worker is the furloughed worker. So they are not allowed to work during the shutdown and not paid. Because they're not allowed to work, they are potentially likely eligible for unemployment insurance. Because they're not paid, they're going to be impacted. We're going to provide some numbers. These are our best guesses. We believe we have in Maryland about 140,000 civilian employees, federal civilian employees. And of these, we think about 90,000 of them are expected to be accepted or furloughed. And again, this is our best guess. Agencies are still making these determinations, federal agencies. We also wanted to provide some information about recent shutdowns to the extent that they might give us a clue as to what the future may look like. Typically, fortunately, they've been short. The average length of the 7 most recent shutdowns is 12 days. So that would be hopeful. The most recent shutdown, though, that started at the end of 2018 lasted 35 days. And during that shutdown, approximately 2,700 furloughed employees applied for unemployment insurance. For those of you that happen to see the sun, just to explain the sun paper, just to explain the difference, 2,700 is the number that applied, 1,500 was the number that actually received benefits. Next slide, please. So as I referenced, we at Maryland Labor have 2 paths to assistance for impacted federal employees, and we're going to go into some detail about that. There is the federal shutdown loan program and the unemployment insurance program, and they serve different populations. So let's go right into it. So on the shutdown loan program, it's new. You all created it in 2019, but we haven't had a shutdown since that was created. So this would be the first time we would have to use it. We hope we don't have to use it, but it's there if we need to. It's funded by the catastrophic event account. And this is important because it is not the UI Trust Fund that is funding this. It's a separate pot of money that the state has available for catastrophes. And this is one that can be used for. If the shutdown occurs, we are set to provide a $700 no interest loan to accepted federal civilian employees who are working in Maryland. And we'll get into that in a minute because that's one sentence, but has a lot to it. If the shutdown is shorter than 2 weeks, we will not issue a loan. That's because all of us, I believe, we're not paid daily. Our next paycheck actually reflects work that we've already done. So the actual impact of the loan, the actual impact of a shutdown, if it should occur, would not happen immediately. If the shutdown happens on the 17th of November, on that next Monday, no one will have lost wages yet, which is why we're holding off for 2 weeks. Next slide, please. Okay, so the loan program eligibility, this is important distinguishing from unemployment insurance. So to be eligible for this loan program, you have to be accepted. And again, as I said, accepted employees or essential employees are required to work, but not paid. And then again, as I mentioned, they can't receive UI because they're required to work. They have to be an employee of the federal government that has been an agency that has been, in quotes, shut down. And they have to have a regular work site in Maryland, which is very important. We'll come back to that in a minute. Federal contractors aren't eligible because they're not employees of the federal government. They're employees of a contractor. So they may be eligible for unemployment insurance. We'll talk about that in just a moment. So how will the application work? If the shutdown occurs on the 17th, which is the current deadline, You can see we already have a portal set up with a website. Residents can start applying as early as Monday, the 20th. We're even specifying the time, 10 a.m. There are going to be some requirements for us to be able to verify that the person is eligible for the loan. So they need to be able to upload a government ID with has a picture, their W-2s from their most recent pay stub, and some documentation that shows that they are accepted status. Each federal agency is supposed to provide their employees with some designation as to whether they're accepted or furloughed. Checks will be mailed as early as the week of December 4th. That is 2 weeks after the 20th, which is why that date is so important. They will be paper checks. We'll be using the U.S. Postal Service. These are loans. So when the shutdown is over, accepted employees will receive back pay, and they will be expected to pay back the loan within 45 days after the shutdown is over. Some important loan considerations that we just want to bring to your attention. We've sort of hinted at them as I've been talking. So here are some categories of workers who are not going to be covered by the loan. And that's based on the way the statute was written, not choices that we're making. Active duty military personnel would not be eligible for the loan based on the wording of the statute. And accepted workers who live in Maryland but work out of state. We know lots of Marylanders work in DC, for example. They also would not be eligible because, again, their location has to be within the state of Maryland. There are specific funds set aside for this, well, as part of the catastrophic account, not for this particular. And they have a limit. We set the dollar threshold in part based to align with unemployment insurance, but keeping in mind trying to make our best guess as to how those funds would be used. It's possible for an extended shutdown that has a high take-up rate, we could run out of money, and we'll certainly work with you if that happens. And then a couple of changes since the last shutdown. Again, there's a guarantee now of retroactive pay for federal employees, and that there are some non-government assistance programs likely to be available through banks and credit unions, which is terrific and important and will be, I'm sure, used if we go through a shutdown, and we list some of those here. So that's it on the loan program. Now I'm going to transition to unemployment insurance. We all know that unemployment insurance has been around for about 90 years, and it's lots of rules and regulations that are in statute. People would be applying through the regular UI system. For the purposes of this shutdown, UI would be available or potentially available for furloughed employees. And again, furloughed employees are not allowed to work during the shutdown, which is why they would be eligible for UI or could be eligible for UI. And an individual who is either a contractual employee of the federal government or one who is working for another company but is under contract with the federal government who is laid off or unable to work because of the shutdown would also potentially be eligible for UI. The application will work the way it works for other people. We will use the Beacon system. It's our online portal. It's worth noting that this was not available during previous shutdowns. And for workers and residents who prefer staff assistance, they can contact the agency. We have approximately 320 staff ready to take claims and provide assistance over the phone. We have been preparing for the shutdown. As we all know, we thought the shutdown might occur as early as October 1. So we have been training our staff if a shutdown occurs so they're ready to take shutdown related questions. And we are ready and we will be ready. Just a couple of details. Again, this follows normal UI. The maximum benefit in the state of Maryland is $430 a week. The minimum is $50. You know, we're not going to go into every nook and cranny of unemployment insurance. We certainly can take your questions, but it's complicated, but dependent care credit, et cetera, is still available. They would be a UI claimant like anyone else. Individuals who are furloughed, if the furlough happens as of Saturday, November 18th, they can file a claim as early as the next day, Sunday at 12:01 a.m. They will, when furloughed employees receive retroactive pay covering the shutdown after they return to work, they would be expected, this triggers an overpayment in UI, and they would be required to pay that back as well. So we know that we were asked questions about how this impacts our trust fund, and thank you. Appreciate that. So it's important to go through the different classes of workers. So for the furloughed worker, there should be no impact to the UI trust fund because furloughed employees would be paid for from a federal pool unemployment compensation for federal employees program. It's not the Maryland Trust Fund. Obviously, accepted workers who are paid by the loan, as I mentioned, that's from the catastrophic fund and also not the trust fund. Where the trust fund could be impacted is the non-federal employees, but who are impacted, people who are federal contractors, to the extent that they are impacted by the shutdown and not able to work. They would apply for unemployment insurance. If they receive retroactive pay, they'd have to pay it back. So there would be no long-term impact to the shutdown. Perhaps that's unlikely. If they don't receive retroactive pay, then that does have an impact on the trust fund. And that's the slides we have for you today. So myself and the team are ready to take any questions or talk with you about how this program might work.
Thank you, Deputy Secretary. Thank you for your very thorough and fast briefing. I think we have Delegate Pippi who has a question.
Thank you, Madam Chair. So I still have PTSD from UI issues and COVID and fielding thousands of constituent. So you had said up to 90,000 people or so may be eligible or apply for this program should the shenanigans in DC continue to November 17th. So staffing wise, and then I guess bandwidth wise, is your agency prepared for 90,000 people to apply for that at the same time? Or are we going to get inundated with thousands of emails and phone calls and that PTSD will come right back?
Sure. Thanks for the question. And we recognize some of the challenges that the agency faced during the pandemic. I do want to go back, and I'm glad you asked the question, to that 90,000 number. Again, a significant percentage of them are expected to be accepted workers, which means they would be applying to the loan. The loan program will not be handled by UI staff. They'll be handled by a separate entity, and it's supported by our staff. Again, it's a new program, so it's hard to know what the take-up rate will be, but we are prepared to step in and address as the needs arise. On the furloughed side, which is where they would be applying for unemployment insurance, we think that we have appropriate staffing. We do have a model where we can expand our staffing if necessary. It's a delicate balance of how much to put in without knowing. But again, part of the reason we want to provide you with numbers that from previous shutdowns is to give you a sense of, and ourselves a sense of how we're thinking about this. I apologize because I'm just popping in, so I don't know, going in no particular order. We'll start from Delegate Queen and move around.
Mr. Chairman, I guess I want to piggyback on my Delegate Pipke's comments. Maybe we can peel the onion a little bit about the numbers and the buckets, because I too worry about that whole debacle we had with unemployment insurance, and we do get a lot of phone calls about this. And so, and I'm a little concerned too that you have a new, you talked about, you have a separate entity that's going to deal with the accepted workers, but you haven't used that before. So again, are we properly scaled to handle that? So, and also have a personal concerns because for all my life until I started working for the state, I was a contractor for the government, didn't work at a federal agency. And so, and sometimes I didn't work in Maryland, mostly in DC. So can you kind of give me the buckets of people in terms of this 90K who you think are part of the exempt workers, accepted workers, the furloughed, and then possibly those contractors who may be outside of Maryland? Do we kind of have some numbers around that so we can kind of expect what to get with each bucket?
I'm going to pass it to my colleague in just a second. And I don't want to sort of pass the buck, but I think what's really challenging for us, just to be clear, is that it's the federal agencies that are designating, and from our reach outs to them, They're not necessarily totally clear. OPM doesn't necessarily know how different agencies are going about this, and they may be changing some designations over time depending on what the workload is. But let me pass it to Rachel Brash, who can.
Okay,
walk through
thanks.
this.
Sure. Yeah, so I would say that the federal agencies have updated their contingency plans. They did that in the end of September. So if you look at the contingency plans, they are updated to that point. And there was an analysis done of the whole federal workforce. And so when you look at that, it's about 34% are designated as furloughed, 29% as accepted, and 37% as exempt. So not affected by, well, exempt employees are affected by the shutdown in that their colleagues aren't present at work, but they will work and they will be paid. So if you look at the numbers in Maryland, there are estimates are between 140, 150, 160,000 federal civilian employees. So that comes down to about 47K furloughed, 40K accepted, and 52K exempt. And so, we know that not everybody who is eligible for a loan will apply for a loan. And I think the UI numbers from the last shutdown tell us a little bit about that. We had 2,700 people apply, 1,500 people, 1,510 actually received benefits. And around that time was the Congress passed the law that assured back pay for furloughed employees. So I think that's an important factor. We know that not everybody who is eligible will choose to apply because they may have a cushion. We also know that many people live paycheck to paycheck, so they will begin to feel the pinch. But we also know that they have an assurance of back pay once the shutdown. Yeah.
Of that 160K federal employees that you're saying is reported, is that the ones that work for the federal government? Is that including the contractors as well?
That does not include.
So we have another bucket, which I'm sure is a larger, not larger, but a substantial bucket who work in this area, who work for a private entity and they work for the federal government. What is the estimate of them? Because they're going to come to our UI. Those are the ones going to come to the UI. So what's that number?
I don't know that there's a number that we can obtain. And I think that's why we're sort of leaning back towards what happened under the most recent shutdown, because presumably there were roughly the same number of contract workers, or at least in the ballpark. And so the total number that applied back then was 2,700, of which 1,500 received benefits. I wish we want to know all these numbers as much as anyone, because it totally determines how we establish our program. And I do want to just follow up to Rachel's point. We will be learning, if the shutdown occurs, people can begin applying on the first day. We will be absorbing those numbers. We would expect the number to be fairly low on day one, because again, the impact will be not so significant, and those numbers will continue as long as the shutdown goes, and we will be prepared to ramp up as much as we can, as quickly as we can.
I would also just add that employees will receive a full paycheck 1 week into the shutdown, so they'll have those resources. Then 2 weeks later, they will not, that'll be the first missed paycheck. So that was one of the reasons we timed our first.
And before we go on to the next, Jason, I have a question. When the follow-up point Delegate Queen was discussing, because when it comes to federal workers, a lot of times will get their back pay and then they'll pay back the fund. Our contractors, it's a different setting though, because they are under contract. So many times the contracts are funded year to year. So ergo, a government shutdown doesn't necessarily affect their current contract, which makes it very difficult to estimate. That's why the number is so low. We have thousands and thousands of federal contractors, but because those contracts are year to year, at least not, if not, but they're funded year to year, if not 5, 7, 10-year contracts, then many of those individuals will be receiving a paycheck because it's contract, at least through that period. Now, it might affect that next cycle or the funding for the next, round of contracts, but am I correct in understanding that?
You are, and of course, they could also be shifted to other projects that are
Correct.
not being funded by, that would be impacted by the federal government shutdown. So
Yeah,
it's,
that's why the numbers are dramatically lower than we would assume for federal contractors, because many of those have money. The contracts still have money. The contracts are funded through October to October, because I'm running through this too, but I appreciate that answer. Next is Delegate Amprey. Nope, is that Delegate Rogers?
Chair, so, and this is, I guess, a variation on the question that Delegate Pippi asked. So we weren't ready when COVID came about. We staffed up. We have something that's about to occur. Do we lose all of those resources, or did we retain, have we kept some of those resources on board to prepare us for what may happen? And do you know what those numbers, can you give us any insight of what those numbers look like in terms of how many people we have ready prepared to deal with the situation?
sure, and I can at some point pass it to my colleague EJ. We didn't necessarily lose resources. I mean, as you know, as time moves on through the pandemic to whatever period we're in now, we are constantly monitoring the data, how many people are applying, how many people are calling, and adjusting our staffing to try to meet those needs. I want to acknowledge some challenges the agencies had, particularly in the pandemic. And we can again sort of ramp up or down based on what occurs in the future. But let me pass it to EJ, who can add some flavor.
Yeah, I can answer that question. Yes. So during the pandemic, we probably had around 1,200 to 1,500 people available to take calls and take claims. And now we do have over 300. The call volume has drastically dropped since the pandemic, and we're very well suited to handle the calls coming in. And in addition, the other change would be during the pandemic, there wasn't just unemployment available. There was pandemic unemployment assistance available and also pandemic extended compensation available. So we were in essence, administering 3 to 4 different programs during the pandemic, whereas now it will only be one program. So we won't have people that aren't traditionally eligible for unemployment, calling for unemployment. We only have those eligible for unemployment, and federal unemployment claims are claims we take, basically every day. So the staff is well versed in how to take those claims. And this isn't new. This is a similar process we've always handled. It will just be, there will be an increase in volume if there is a shutdown.
Okay, and then with respect to the federal contractors, so there are different buckets of federal contractors. You do have those folks that are on 1-year funding. You do have those folks that are on 3-year funding. You have those folks that are in military construction that are on 5-year funding. Have your models taken a look at the differentiation of the type of federal employees that are going to be impacted should we have the shutdown?
I don't think that we have models, unfortunately, that can go into that level of detail. I wish that we did. And I don't mean this to be taken the wrong way, but to some extent for us, they're all in the bucket of someone who may be eligible for unemployment insurance, whichever type of contract they are, and really the same whether they're a federal contractor or a furloughed worker. We will, they will be able to apply. We'll look at their conditions or eligibility and either award unemployment insurance or determine that they're not eligible. But again, we're desperate for as much information as we can so that we can set up our resources to meet the need.
Thank you.
Delegate Arentz.
In fact, we're still running through problems with UI. I get calls and my office spends an unbelievable amount of time following up. We have to expedite. We have to call somebody more than one time. We're taking notes on these people. We're filling out forms to get to UI. How can you assure me that we're going to be rid of you? I mean, I don't want my office having to do that. Everyone here has had an enormous amount of staff time compensating for what can't be done at UI for various reasons. But how can you assure us that it will not be every day we're getting a call from the same guy, no follow-up from UI, constant? How do you assure us of that, our office?
I appreciate the question. And I would just assure you that we're getting calls as well, whether you're a person who works on the UI team or in the office of the secretary, we're getting calls. What we're trying to do is, and we want to be, we don't want to have the calls because we want everyone to get the benefits that they're entitled to get in a reasonable time frame. What we're trying to get to is the underlying root causes of why people are having challenges getting through the system and address those root causes, which we are I think we're making progress on. Some of them are involving the way the system is set up, with the way people have to provide documentation to essentially prove who they are and that they're eligible for benefits. And we're trying to, again, get to those roots so that it's, yes, we want to make sure that we're helping person by person, whoever you all, whichever constituent you have, we want to work with you and make sure that they get their benefits, but we want to figure out what's the common theme so that we can address them. We have been making improvements. I think there'll be improvements being made between now and when the shutdown might occur. I would love to tell you that you're not going to get any calls about unemployment insurance. I really wish I could tell you that. I don't want to tell you something that I don't feel comfortable saying.
I guess my biggest concern is we're still collecting data when that's not our job. That's your job. People are
Agreed.
calling us, and when you do address the issue, somebody calls that person, maybe we finally do get a contact, they do that, and then it drops. Then I'm getting a call up, well, I talked to somebody 3 days ago, I sent something in, and they're calling us. And I want to know how that is going to be facilitated from your end, that we're no longer playing in that.
Yeah, we don't want you to have to play in that. So
I don't want to. That's what I'm saying. What are you doing to prevent that?
yeah, so I would say, and again, I'm happy to pass it to EJ. I think we're trying to get to the underlying causes so that you're not getting the calls, but we can also do a better job of communicating with, there's no doubt we can do a better job of not only communicating with you and your fellow elected officials, but also the constituents that are calling you. And I think some of that is the problem, is that they're going through a process, they're getting frustrated because they're not hearing what we're doing to resolve the issue. So let me just see if EJ has anything to add.
No, I mean, in addition to that, it is a different landscape now with UI. During the pandemic, almost everybody that applied was eligible for one program or another. They were eligible for unemployment or they were eligible for pandemic unemployment. And now that the pandemic programs are over and it's just unemployment, it isn't it's a program you have to be approved for. And unfortunately, some people aren't eligible and sometimes they don't like the answer to that question. So when we tell them that, they may go around us to other people to try to get a different answer to the question. And I'm not saying that's the case for everyone. And I know for a fact, I mean, I share Jason's sentiment. We want to get to the root cause of the problem and why are people going to you and not coming right to us with the issues. So
they are coming to you. They're trying to get a hold of you and they're not. You call up, I give you an issue, I give a complaint to you. That they get that follow-up from you, they call them back, then that issue is back on us again because they're not getting the right answers from you all to address that problem. And that problem's now, that's still happening. And I'm not comfortable that it's not going to continue and get worse if we do experience a shut.
I think, again, I would love to.
I'm beating a dead horse.
No. And we would love to talk with you more about the issues that you're seeing and your fellow members of the committee. I think what we find is often the case is around ID verification, that they're getting either they're not able to upload their documents. We've made some changes there, or that when they upload for whatever reason, it's getting a fraud tag, which doesn't mean that they are trying to commit fraud. It just gets sort of moved into that bucket. And that's not a bucket we want people who should be receiving benefits to receive. So it's what we're trying to do on our end to make sure that people who are truly eligible, that doesn't happen to them. And that is, I know that can be especially frustrating for people, and we're love to work more with you.
Thank you.
I feel like I have to expound upon the issue that the good delegate raised, because at the end of the day, when constituents contact us, they've already contacted you. And the problem is when they don't hear back from you, we have failed. And they see it, and this is not a political issue, but we rely to our detriment sometimes on other agencies. So instead of me calling you on behalf of a client or a constituent, I will in fact send that constituent to you with, in my mind, the handshake has been made. The problem is if it hasn't, then they don't remember what you did not do. They remember that we have failed them. That was never our intent. So I would ask you, and I don't know if there's a way this is already set up, that whenever an elected official sends you a request, that there's got to be some follow-up, at least with that elected official, to say, hey, this is where we are in the process. And I know that that is time consuming. I know that that's a problem, but it is a huge problem for us because we are dumbfounded when 4 weeks later they've called back. And you know what our answer always is? I don't know. I'll have to get back to you. That's us failing them as elected officials. So I myself would appreciate some kind of processes set in place that were in any one of my colleagues in this entire state house reaches out to you, that there is a follow-up, that that person is flagged, that you know that that is a person of interest to us. And I know this is a big ask, but we have a job to do. And when we can't figure out where this person is and they've fallen off our radar because many people have other jobs, family lives, as well as this job is all encompassing. We assumed that when we gave them whatever contact number we gave them, this situation was done. And it is very heart-wrenching to get that call weeks later and be unable to provide. So if you could set up some kind of methodology, if we're sending somebody to you and maybe that takes something on our side to where instead of just giving them a number, we're sending an email directly to you. Steve, you listening? Because no, I mean this because I'm trying to get some agreement here that if we can create like a ticket, then that ticket has to be kept alive until it is closed. Because I don't feel comfortable anymore, because I know you guys are doing a yeoman's job, but again, because things aren't moving, they call us back. We have no idea, even if you guys are doing something. So I would encourage all of my colleagues to do things in writing and not just give a number, do an email. But I would also encourage you guys to have some way of creating an open ticket for any time one of the elected officials reach out to you with a complaint until that ticket has been closed.
Mr. Chairman, and other committee members, we don't want to put you in that position, and we also don't want your constituents to be in that position. So we'd be happy to work with you to develop a process by which we can get back to you. And again, if it's not, it's our failure if they're not here. If you have a constituent who hasn't heard from us in a month, it's our failure. So we would want to know about those situations, make sure we're addressing them and do a better job.
So if you could have some kind, and again, this is just some, put your heads together, how you would like us to formulate these issues and these complaints when they come to light so they can be followed up on. What process you want us to go through, and I'll make sure the entire State House gets this, to know that when we get a citizen's complaint, if we send you an email, if it's an ombudsman, however you choose to do it, that we can always call and get, I don't want to, not anybody's gonna be calling day to day, but if we, at any one day, if we call to say, well, hey, what's happening with Mr. X, there it is, it's open, not a problem.
Absolutely happy to work with your team. We'll come up with something.
Thank you very
Quickly.
much.
Yep.
No. Oh, no, but you can hit the button, but I just gotta wait in line, sorry. Delegate Charkoudian, I believe, was next, according to this list that she created, not me.
I created it. I put my name at the top. Thank you, Mr. Chair. Thanks for this, and thanks also for scrambling to put this together. I think we passed the bill in 2019 and the previous administration should have done the work to put together the loan programs. I realize that you inherited it after 4 years of nothing being done, and we're scrambling to get this done in time for this this shutdown. So thanks for doing that, imperfect though it may be. And I share the concerns of all of my colleagues. I continue to get those calls myself. We've had numerous conversations about it. And I also just wanted to ask specifically, Andrew and I worked a little bit on language that I used and others I shared with others that we could include in describing these various programs. If I could just ask for that again, some very specific, like one paragraph we can all include in our outreach that says there's this, and if you're this, then you pay it back, and there's this, and right, sort of that sort of a thing, which I think I got pretty close to in what I wrote, but I would love for you to have language and to share it with everyone here so that we can prepare people. I think it both is important so they have accurate information. It's also important because people are feeling really stressed right now about what's going to happen. And so if they can see in advance what's in place to help them, that's useful. I had one other question. Did you want to respond to that before I ask?
I would just say we're happy to work with you and other members of the committee. We totally share that we want to relieve as much stress as possible. We also want to direct residents to the right path so that it's faster for them. They're not having to make multiple calls. It is a little confusing, accepted versus exempt versus furloughed, but there's not much we can do about that. But as much as we can put things in plain English, we will do so.
Yeah, thank you. The last thing is I feel like it would be irresponsible of me to have you here and have my committee here and not raise this issue. Andrew and I and the secretary and I have spent some time engaging on it, but I want to make sure everyone's aware that our trust fund is going to be in real trouble in a couple of years. And it's really important that we all talk really transparently about that and the kind of actions that we need to take to make sure it's not in trouble, because if we're not acting on it now, then we're going to be scrambling Right now, there's plenty of time to phase in changes, to do it responsibly. But if we wait longer, I've been raising this issue since 2021 myself. If we wait any longer, we're going to be in a scramble mode where we won't have as many options in front of us. And so just want to make sure that that's on everyone's radar. And while you are here, if you want to take a minute just to talk about that. And, of course, I've shared the research that was done by the University of Michigan under a contract with the Department of Labor with everyone, and I'm happy to share it again. We've also shared some modeling of some different kinds of approaches to it. And look forward to working with the Department of Labor and my colleagues on a solution this year. But I just want to ask you to speak to that, if you would, for a minute while you're here, just before we get into the legislative session, since you probably won't be here before the legislative session again.
Sure, happy to. And thank you for your leadership on many things UI, especially the trust fund. I know that you and Secretary Wu and Andrew and probably some folks from the UI team have had a number of conversations. And, we don't disagree that the trust fund, while not under immediate threat, there are some systemic issues that need to be addressed in the near future, and look forward to working with you and the committee to think about the best way to do that, to balance the immediate needs while also preparing for the long term.
And good. And I also just wanted to, again, piggyback on that with that basically last year, this was an idea that we've been working with as far as fixing that table. It makes very little sense that in good times you pay the least and in bad times you pay the most, and it crushes small businesses. And, we understand the health of our trust fund is important, but basically last year we did hold Delegate Charkoudian back. I think this year, because you guys were new, and we wanted to give you guys a little chance. So we tried, but I don't think we're going to be able to do that this year, because we have to have a definitive solution. I look forward to the options that she is going to provide for us, but we cannot continue to have the table this upside down. We've got to find a way to fix that table without jeopardizing the health of our trust fund. So I want you to understand, last year we were being cool. We were kind of let everybody get their feet wet and on solid ground. But obviously this year is going to be different. So it would be great if well ahead of time, before we, release the dogs of war, that we have dog of war. I apologize. No, but because I know that she is very dogged and very good at what she does. She's very dogged at it. So I want to make sure that you guys, before session, it would be great if you guys had a comprehensive plan with the good delegate and chair of that subcommittee and your secretary. So I do look forward to hearing that. And also, just to backtrack, when it comes to communication between the constituency and my elected officials, a lot of times it seems like the adjudication is a time-consuming process. It seems, could you please just, when you respond, kind of put the electeds on, make them aware of, how long this may take? Because it's one of the things that when they call us, we can say, look, we told you it's going to take about 6 weeks. Or as we understand these processes, because again, we don't know the work that you have to do and the time that it takes and the verification steps and all that. But in situations where you can, updating the electeds on just how long this is going to take. And I understand you probably tell the people when they call, but they do forget, they're frustrated. So we could reinforce whatever it is you're explaining to them when you update us. So again, what a turnaround time would look like. And I know it changes, but when you can, so we have an answer when they call. I believe the next person is Delegate Fennell.
Appreciate it. Thank you, Deputy Secretary. It's good to see you and your team again. My question in reference to what you talked about the legislation in 2019, when we did the legislation in 2019 in reference to the loan program, did we take in provision in reference to that constituents who work 100% remotely in the state of Maryland? Because as you talked about the brick and mortar being in Washington, D.C., do we take in provision in making sure that loans are provided for the 100% remote federal workers in the state of Maryland? Did you all take in hand in reference to, because I know we did this in 2019, but
Yep.
since then there has been constituents who's working remotely in their homes in the state of Maryland.
Yeah. It's incredible how much the world has changed since that legislation passed. Obviously, that was essentially pre-pandemic or when the pandemic was just starting and none of us really knew what we were about to go through. We know that telework, virtual work is totally different in 2023 than it was in 2019. None of us could have anticipated the rapid changes that took place. In terms of the eligibility for the loan program, a Maryland resident can be teleworking and be eligible for the loan as long as their regular workstation where they're essentially assigned. We've had a little debate about using the term duty station, but as long as their regular workstation is in with a Maryland agency. So they would, whether they are teleworking or they're going to actual office every day, wouldn't matter. What matters is the agency to which they are working for. If it's a DC agency located in DC, that's their regular duty station. Then as the law would be, as a statute says, they would not be eligible for the loan program. Be happy to work with this body in the future to consider adjusting things.
Am I on? Okay. First, I had 3 questions, but by the time it gets back around to little old me, y'all have asked it. Okay, now, Mr. Chair, first of all, I want to say amen to you. Okay. I mean, I don't think that we got an amen of all the problems that we've been going through with this system. Mr. Secretary, I want you to know all of us elected officials have been through this to that. I'm not going to say that word, but on this problem with unemployment. And that was one of my first questions, is saying an amen to my chairman. Second question I wanted to ask, and it probably been already answered, is there, in paying back the loan, is there, what is the word? How long do they have to pay it back? I mean, before y'all send them to the collection agency. Okay. Is there a limit on how long y'all will send them a notice to tell them, okay, you got the loan, okay, now it's time for you to pay it back, and you got 6 months to pay it back. I mean, it might not be that long, but what I'm saying is there something in writing that they have to pay the loan back at a certain time?
Yes. Great question. And they have 45 days from the end of the shutdown to pay back the loan.
45 days at the end.
At the end of the shutdown, once it's officially over.
Okay.
They have 45 days. And again, for this group of people we're talking about, they will be receiving retroactive pay. People have different financial situations. I'm not necessarily minimizing that it's necessarily going to be easy, but they should be receiving their money back once the shutdown is over, certainly within that 45-day period.
Okay, within that 45 days, do you send them to the collection agency or what? Who sends them to the collection agency?
We will not send them to the collection agency in that period of time. So 45 days is the repayment window. We will send them multiple reminders that the loan is due after 45 days. And we've said it clearly in the application. What we also say is that, so what happens with collections is that, and it's required by the Central Collections Unit, which is the unit that will be responsible for collection. They must receive a 30, 60, and 90-day late notice. So they will receive those. After that point, after that 135 days, that's the point at which the account will be sent to collection. So it's a nice long window. There will not be a financial penalty in those 135 days because this is a no interest loan. The fee that will be applied is the CCU, once an account goes to collections, is the 17% collection fees that is required by CCU. And again, we're saying that in writing as often as possible, so people know that it's not a surprise. And so that's the window, and that's the only potential penalty beyond the repayment.
Okay, and just one more question, Mr. Chair. I don't know if you said this or not, but have you been dealing with a lot of fraud? I mean, people giving somebody else's information, they're giving wrong information, got somebody else's ID, social security number or whatever. Are we still going through that?
We are, and every state in the country is going through that. And, you know, what happened during the pandemic is that pre-pandemic incidences of fraud were fairly unusual, and they were typically one-offs. It was an individual looking for one benefit.
Mm-hmm.
Once the pandemic hit, everything became virtual. Again, this is not a Maryland specific challenge. It's everywhere across the country, and it's not even limited to UI. People who are up to bad found creative ways to inundate state agencies with fraud attempts. And that's part of the devious strategy. By inundating, submitting 1,000 or more fraudulent claims, they're trying to overwhelm the agency so that some of these claims can get through. And part of what's so terrible about it, not only is it, you know, possible that the fraud will get through, but to the questions that we had from the chair and the delegate about, you know, good, honest Marylanders who are trying to get their benefits, it impacts them because, again, we're dealing with this inundation of fraud that we're trying to sort through. So we are constantly trying to work with our colleagues to come up with strategies that will identify the fraud quickly, move it off to the side, make sure that they're not paid benefit. And we can focus all of our attention on the Marylanders who are honestly applying for benefits. But it's not something that is going away. I mean, it's, and again, every state is dealing, we're in constant conversations about creative ways that we can find to be able to prove people's identity quickly, verify that they're eligible for benefits faster than we've ever done before. But while we're doing that, unfortunately, there's some people out there that are working on the opposite way. They're trying to find, for every solution that we come up with, they're trying to find a way to make our solution not work.
And Delegate Pippi, I know you had a question very similar, but you were talking about a specific number as well, correct? So please go ahead.
Thank you, Mr. Chair. I'll just be quick. So I think you alluded to most of it. It was more specifically like what specific steps have you taken to, because I know there was about a $500 million fraud that was uncovered kind of at the tail end of the pandemic a couple of years ago. It's a lot of money, a lot of taxpayer money. Just, you know, with this upcoming potential shutdown, maybe you'll get inundated with thousands of requests. Is there anything that has changed since the last couple of years to maybe identify what would look like a fraudulent request versus, you know, utilizing what we've learned in the last couple of years? Is there something else in place that the agency has put there to counter against potential fraudulent claims? I know you're getting to it. I was just, you know, if you could maybe address that, that's all I had.
Yeah, I will pass this to my colleague EJ. I would just say, I think what we've done is learn from past mistakes and again, try to look at the ways in which people who are not trying to commit fraud were sort of being tagged as potential fraud. So again, ways that we can make it easier for them to upload their documents, ways that we and our partners can look at the documents they upload and be more sure that they're legit, while on the other hand, having processes in place that are tagging the cases that are more likely to be fraud. And I know EJ can talk about, without in very general terms, a situation that just happened last week.
Yeah, we have multiple like checks and balances in place for this. So and a lot has changed since the pandemic. We have a vendor that basically looks at every claim that comes in to see is it coming from a legitimate IP address? Is it coming from a legitimate machine? Where is it coming from? Is it coming from the US? Is it coming from another country? So like, again, without going into too many details, we look at that. We also ask people to verify their identity. You know, sometimes they upload documents like a passport or a driver's license. We manually review those now to make sure they're legitimate. We also, in the process of taking claims, we will ask people specific questions that they should only know the answers to. Very similar, like if you ever apply for a loan or anything, when you do a credit check, it'll ask like, what type of car did you own in 1999? Those kind of questions that only they should know the answer to. But in addition to that, as Jason said, we're constantly revising this and seeing, you know, what works and what doesn't work. You know, we are in constant contact with other states to find out what other states are doing, what are they doing that works and what doesn't work. And then we're constantly, you know, learning and changing our policy. So, I mean, I'd be happy to discuss a little more detail, you know, offline. Yeah, but in general,
yeah, we're trying to actually not put too much on the record about what we're doing. Yeah.
Thank you. Mine are simple. Thank you, Mr. Chairman. UI requests, notwithstanding the federal issues, have you seen an increase in UI requests?
No, we've actually seen a decrease in UI requests, but so that's good news. The economy is relatively strong, which, you know, there's a direct relationship. However, the call volume hasn't decreased as much as we want, which gets back. I don't want to keep talking about this underlying issues, but why are people calling repeatedly? If we can solve these issues, it will drastically drop our call volume.
And is one of the systemic issues that you were referring to with UI just the cost of inflation, the cost of living? Is that built into UI at all? I actually don't know.
It's really not built directly into UI. The benefit rate is established through statute, and so that would be something that you all would work with the governor's team to.
Right. Thank you. No, I'm just curious. Thank you. I was curious.
But I do want to just connect the fraud challenges to the challenges that residents experience, right? Because the more checks we put in place to prevent fraud,
sure,
unfortunately, that's a frustration that residents will experience. Why are they asking me all these questions? I'm in desperate straits here. And I just want to make sure that you all know we get it. We understand their frustration, but we have to, because it's, again, not one-offs. It's by the thousands at times.
And I just want to say thank you for your presentation, obviously for the answers, but kind of following what you said, I understand that the checks are there. That's why a timeline, an expectation would be important. And again, please let the secretary know that I do have expectations. And while last year we were delicate and we handled things with kid gloves, I don't think the same thing is going to be said this year, especially if we're still dealing with that issue and that lack of communication by session. So I firmly expect there to be a resolution in a short order that allows each person in this room and all my elected officials to be able to follow up on any complaints that we send your way. You tell us how you want it done. We'll make sure it gets done that way because we want to have answers. And I look forward to you guys working with the chair of unemployment to come up with a viable solution that tends to the health of our trust fund, but does it in such a way where we are not penalized at the toughest times that these business owners face. So I appreciate everything you're doing. I look forward to meeting with the secretary and myself on a personal level to discuss some of this. And thank you for your presentation. Colleagues, I believe now it's time for lunch. Yes, I believe until 1:30. I spent my own money buying y'all turkey some food, so please make sure y'all eat it. Thank you.